Can you hear me? Hey. Is that Annette?
Yes, this is Annette.
All right. How's Luna doing? And sorry, that was Chris.
Yeah, Christine and Dustin Lang.
Okay, great. Thank you for joining us.
Is there someone else? Because they said there are 3 participants.
The Langs are on as well.
That's just been...
Yeah, it might be including us because we end up having to use a cell phone to dial in, so that might be the third is this phone.
Oh, that's unfortunate. That's why things are cutting out, so we have to be really careful not to talk over each other.
Okay. All right, why don't we start with introductions. I'm Tony Roisman. I'm the chair of the Public Utility Commission, and I have a number of our staff here, most of whom have some dealings with participants and Pro Se participants in particular. But why don't you introduce yourselves?
Kyle Landis-Marinello. I'm general counsel here at the Public Utility Commission.
And I'm Margaret Cheney, one of the commissioners.
I'm Judy Whitney, clerk of the commission.
Ann Bishop, the Commission's Operations Director.
John Brabant, Vermonters for Clean Environment.
Holly Anderson, deputy clerk of the commission.
Tom Nauer, I'm the policy director for the commission.
Greg Pierce, I'm a private citizen.
Sarah Hoffman, I'm one of the commissioners on the Public Utility Commission.
Tom Shea, I grew up in Searsburg and was an intervener on the original project in '96. My mother was, and was an intervener on the one that just went online.
Deerfield.
Deerfield, yeah.
Lisa Lados, I'm executive director of the Wind Action Group, and I was an intervener on the Deerfield Wind Project as a citizen.
Okay, well, thank you all. Thanks very much for coming. As you know, this is one of a series of listening tours that the Commission is doing to better understand what our stakeholders think about our processes and how we function. We don't object if you want to say something good, but we understand if you've got problems, and that's the primary focus, and we're glad to hear those. The only, if you will, ground rule is that we obviously can't talk about any case that's pending, so to the extent that any of you are involved in a current case in front of the Commission, we should not be talking about that. Oh, and I nearly forgot, we have 2 people on the phone. Please introduce yourselves. Annette?
Annette Smith, executive director of Vermonters for a Clean Environment.
And,
Christine Lang, private citizen.
okay, thank you.
Dustin Lang, resident of South Carolina.
All right, nice to have you here from South Carolina. I thought we'd start, just take a couple of minutes to tell you things that are currently going on and that are intended in the near future that we hope are making our processes more both accessible and effective for Pro Se participants. Margaret, do you want to start?
Yes, so some of you will know that we've been thinking and focusing on this for a couple of years now, especially Greg Pierce, who is here, was a regular participant in our Act 174 working group, as was Annette Smith. And the focus of that in 2016 was in response to a legislative act a section in an act to see how we could improve public participation in our processes. So we met throughout that summer. That resulted in a report, and we've been trying to make improvements ever since. We realized that we had a problem. It was difficult for the public to participate, and so we looked at many diverse ways to improve our interaction. Some of that resulted in some statutory requirements in 2017 legislative changes, and many of them came of our own initiative because we saw this as an important goal. And just to remind you of some of the things that we've been trying to do, a major effort, and that had been ongoing before the Act 174 working group, was EPUC, which we think and hope has made it easier for people, at least who have access to our to internet, to participate, to follow our cases, and stay informed. We have made a concerted effort to use lay language more, as much as possible, and in fact we've redrafted and created certain documents which we are going to make and are making available at hearings for people to pick up, but are also available on our website and are going to be distributed as a matter of course to certain adjoining landowners, etc. One of them is a more lay approach to what was the Citizens Guide to the Act, to the Section 248 processes. Now it's just a guide to who we are, and there's a separate document on how to participate, including step-by-step how to become an intervener. We've also had mediation training for our hearing officers to make the interaction more friendly, you might say, and more cooperative, because we know it's been somewhat top-down and sometimes confrontational. We now, as a matter of course, are required to be held an information session before our own public hearing, so the public is informed as to what they're about to comment on. That's put on by the department and the petitioner. We put into our orders the public comments that we've heard and respond to them, and we also ongoing have those comments that help us to ask questions, things we may not have known about, even if they're coming from someone who's not a formal party. So that's just a quick summary. There are other things, but I think that I'm just trying to summarize the spirit of what we're attempting to do, and I realize it's always can be improved.
Sarah?
Yes, thank you very much. We're trying to modernize the hearing room, and I'm going to first apologize. It has taken far too long. I have been worried about getting John out of having too much free time, because once we start streaming them, he may not have to be doing this anymore. But it has taken too long. We took a wrong turn and got way too techy, and we are now correcting course, and we hope in the near future to be streaming our proceedings, as well as allowing a few people to appear in our hearing room via video conference. So it's not going to be like 10 people out there. It'll be a couple of people, maybe present a witness, things like that will make things easier. But we do hope to, we're having another meeting tomorrow. We do hope to have something in place in the near future, but apologize for the delay.
And just, you should know that this is a work in progress, so nothing is done. We're working towards that. Most of my career was spent representing people who were essentially going to be pro se until they had a bake sale, and then they were able to hire me for an hour or so. I come from that perspective, and so we're continuing to work to make it better. The participation by the public in our proceedings is extraordinarily valuable. We know that people don't always get the result they want, but the input helps us frame the questions better, makes us think.
Is someone typing even the cell phone? Because
I think someone doesn't have
what we're hearing on the phone.
I think someone doesn't have their phone on mute, so we are hearing someone furiously typing.
I don't know who that is.
We're naming no names. Anyway, we'd now like to hear from you guys, and start wherever you like. Who would like to start?
If I may, this is Annette, and I was typing to John saying I wish they could dial in with the landline, because the cell phone connection is really unfortunate. It's very hard compared to a landline.
back, so it's online. So I don't know if it's just the speaker's not on.
I think the microphones might be separate from the
Right.
actual phone system.
Does the pad still say registered?
It says phone not registered.
Something's not online.
If we bring it, can we bring a different phone down, or is it the line?
What if we try unplugging it and plugging it in again, see if that makes a difference?
All else fails?
Oh, Microsoft solution, huh?
Yeah, right.
It works for so many things.
Not the coffee pot, unfortunately.
No, nor your car if you're going down the highway.
Yeah.
You're used to,
Soon.
when everybody drove a standard.
Yeah,
That's true, just go downhill, right?
Throw it in gear and pop the clutch.
We do apologize, the state's VoIP phones all had some sort of bug, and they had to do some massive thing, and I don't know if this one was corrected or not.
It's loading. It looks like it takes a little while for it to turn on. The screen is, the picture is changing, but it's not yet at a place where I know if it's going to work.
Thank you. I'm using Skype, by the way, on my computer, which is much easier than a phone.
Yeah.
So that is an alternative. Okay, let's get back to the work.
Okay.
Annette, the good news is we can hear you really well on this end.
That's why I use Skype.
So if you want to start, I mean, does anybody here mind if we start with Annette?
I don't want to start. I want to listen.
Okay. All right.
Sorry, she just passed the buck.
All right. Well, Lisa, you can start, and people should jump in.
Yes.
We want to hear whatever you have to say. We're going to be quiet.
Thank you, Mr. Chairman. Everyone, I really appreciate the opportunity to be here. So I've been through the process in the Deerfield and also been through the adjudicative process for a number of wind projects in the state of New Hampshire through their SEC process. It's very similar in terms of, it's a, get the word for it. It's a contentious, what is the word for it when you?
Argumentative.
It's obviously, it's a, similar process. In the event that, I don't know a better way in terms of the trial-like process. I think that is the only way that really works. It draws out all the information. I know that it can be intimidating for people who have not been through the process, and it really is a learning process. But I did want to focus on some of the things that can be done, I think, to improve the process. And I want to apologize in advance. A number of the points I'm going to make will sound, they're wind-related, but to the extent that they can be used for other proceedings, that would be good. The first thing that my immediate reaction is the application process. Okay, so by law, the application, the requirements established for the applicant are fairly generic.
Welcome to Open Voice Audio Services. Please enter your conference room number followed by the pound or hash sign.
Just hold a second. It looks like she's got a blip.
Conference room number accepted. If you are the organizer, press the star key now. Otherwise, please hold.
Don't press the star key?
No.
Okay.
Just keep this on and do that.
Okay.
For a menu of available commands, press star 1. There are 4 participants in the conference.
Okay.
Just mute yours.
Kyle, why don't you just hang it up?
Because she didn't.
Well, because this is the organizer.
Does that matter?
It seems like it's muted.
Let me take it outside. I'll figure it out.
Throw it in the parking lot.
But don't hang it up.
I won't.
So how does that sound for the folks on the phone?
Is it better now? Do you-
We'll know when, that's much better, yes,
Okay.
thank you, although I thought we were taking off to Mars.
We did. We've achieved orbit. Oh,
Thank you very much for doing that.
all right, good.
So Lisa, you were at the application process.
Yes, so it tends to be, so for instance, in the case of a wind project, they'll be required to.
The organizer has disconnected. The call will now end. Goodbye.
Oh, God. Oh,
Sorry.
can you call it back from that?
Why don't you just call back
Call
from
back
the,
from that
from the main?
Just disregard your phone.
And we'll go past the moon if necessary.
Yes. Yes, this is eating into your time.
Welcome to Open Voice Audio Services. Please enter your conference room number followed by the pound or hash sign. Conference room number accepted. If you are the organizer, press the star key now. Otherwise, please enter your PIN followed by the pound or... For a menu of available commands, press star 1. There is one other caller on the call.
Yes.
All right, so we lost one caller.
Well, that would have been.
No, it's just,
No, it says that there's one other caller.
Yeah.
There are two people. Hello?
Hey everyone, do we have you back? Sorry about that.
Yes, we're back.
Annette, are you back? Annette?
I'll try to email her.
I'm here, I'm here.
Great.
All right, where's
Sorry.
my-
Sorry
I'm
about
here.
that.
Yeah, try third time should be.
Okay, everybody that's on the line, can you please mute if you're not talking, because we're getting echo.
Okay, Lisa?
So, okay, so you could, in the case of a wind project or any of the projects, they'll be required to submit a noise study or some wildlife study, but there aren't a lot of details on what should be submitted. We know that the project, that it has to be shown to not have an undue adverse effect on public health, undue adverse effect, or unreasonable adverse, undue adverse effect on other components that have to be looked at. But in general, the developer or the proponent decides what goes into those applications and could be penalized in the end if he's omitted information. I think that, and in the case of interveners who want to participate, they may find themselves drilling down into topics that are simply not relevant from the commission's perspective or by law. So I think that a lot can be done to, particularly on technical issues, to really nail down what is required for the application. And for instance, and I'll give you a case in point, in the case of decommissioning, it's not enough to submit a decommissioning plan. What does the state of Vermont expect of a decommissioning plan? And what does it mean to fully decommission a project? In the case of a wind project, you're taking the turbines down and everything. How far, what is the depth down to the foundation? Is it 4 feet? Is it 10 feet? Is it the entire foundation? And what does that mean in terms of decommissioning? Does everything get transported off-site, including the foundations? Do they pulverize the foundation components and rebury them? So a lot, there's inconsistency and frankly unknowns right now, even on the Deerfield project. What is going to happen with the foundation? I don't know the answer to that question. So things like that can be nailed down and known in advance, and then no one has to argue about it. No one has to find out later that something wasn't done that should have been done. And I know that the state of Vermont, and I applaud this, does not allow for salvage value to be netted out. That should be made. It obviously shows up in your orders. Make that part of the rule. Noise. The noise studies. It's not enough to establish up front what the noise limit is. You have a 45 dBA 1 hour, LEQ 1 hour, maybe it's 42 at night. Whatever the standard is, that's only one component of a noise study. The other component, and this applies to lots of things that have to do with technical issues, is the methodology that needs to be followed in terms of conducting a noise study. So in the case of Deerfield, Wind was required to come up with a protocol for conducting post-construction noise study, and that's fine. But their protocol could differ from the protocol used in Georgia Mountain, could differ from the protocol used in Lowell Mountain, and that cannot be the case. What has to happen is, especially in technical issues where there's already enough knowledge out there, we should have reliable, repeatable results. And that way, we don't have a situation where after the fact, well, the way that the study was done, is there's a fight over it. You know, we really should be able to do that. So I think a lot can be done to nail down under rules what the application has to look like and what the processes are for post-construction compliance. So the other area that falls into that is aesthetics. Aesthetics is a big deal, especially with turbines, and it's going to affect other things as well. But for instance, what is the visual impact assessment? What is the distance that's going to be done? I don't know. Actually, I honestly don't remember if Vermont has a distance, but is it 10 miles out? Is the visual impact assessment going to be done out to 10 miles? Is it going to be out to 15 miles? And is a cumulative impact going to be taken into consideration? So if you have a wind project in location A and another wind project in location B, and they're separated by some distance, you could see both. At some point, you'll see both of them. Do we start to get, are we looking at each project only individually or understanding the cumulative effect? That same kind of discussion has to apply to transmission line as well. The other thing that was problematic, that came up with Deerfield, and I would caution this in the future, and I'll just throw it out there because I'm not sure the best way to deal with this, but in the case of Deerfield, the project was approved, the proceedings were in 2008, the project was approved in 2009, actual construction of the project was end of 2016. In between that time, we had a significant period where we were going through post-construction compliance reviews, and the turbines changed in height and size. Their size changed, their noise profile changed. They just were different turbines. And so the applicant produced new visual impact studies. I produced a new noise study. And there were issues associated. I personally, as an intervener, thought there were issues, but there was no hearing to discuss those. And there were inconsistencies with the way the visual impact study was done back in pre-2008 and the way it was done after. And so nailing down, the point being twofold, nailing down what is required for the visual impact study in terms of how the visualizations are done. And there is a lot more knowledge today than there was in 2008 on standards for producing visual impact studies. But to the further point, if a project changes like that, I think that it's important that the interveners be more. It's not enough to submit comments and get a response back because they are very technical issues, and it's hard to assess what the issues are with writing. So what happened was the state of Vermont and this commission has been fantastic about including the interveners after the fact, so in the post-construction process. Many of the conditions that were established in the CPG did state that the interveners will have an opportunity to participate and comment on the post-construction compliance review submissions. But in some cases, I think that it should be considered that there will be hearings. Other thing, so okay, so and I'll just go really quickly for the interveners. One of the issues that I've wrestled with, and it happens over and over again, and that is the interveners' relationship with the agencies, okay? And so the Department of Public Service has a significant role, the ANR has a significant role in these proceedings. the interveners don't really have that relationship that the A&R and the Department of Public Service would have with the applicant. So and I have found repeatedly that we were cut out of that process, or sort of not. It's, you know, in fact, some cases it was confidential, the communications, and maybe there's good reason for that, so I'm not going to comment on that, but confidential communications between the Department of Public Service and A&R that we weren't privy to, or there were negotiations between the agencies and the applicant that the interveners were simply locked out of. And I don't know how best to negotiate that, but it had it could really cut us out, and we weren't part of it. And so it was like, well, you're the public, you don't really, we're doing our thing, this is our, and I understand that there can be side agreements happening between interveners and the applicant in the process, but in some cases we were just simply cut out. We weren't even made aware that they were happening. And it goes to a point that was raised, the other point being that when these kinds of discussions were happening post CPG, so many of the interveners had already stepped out of the process, but others were still wanting to be involved, engaged, and we weren't even aware that the meetings and discussions were happening. So to the extent that they can still be part of the process. People have asked the question about whether or not money should be made available to the interveners. So that, and I know that states like New York currently have that. Wisconsin currently does that, and I'm not sure. I think the money might come from the proponent. I'm not sure, but money is made available and allocated in order to help them go through the process. And originally, I didn't think that was necessary. I thought, okay, so the interveners get involved. They may not have the money to bring an expert witness in. The applicant brings his expert witnesses. It should be enough. This is just my thought at the time. It should be enough that the kinds of questions if you can tear apart or really identify holes in the applicant's witnesses' testimony, that would be enough to sort of make the point for the commission. But in fact, it doesn't work that way. I haven't seen it work that way, and maybe this is, you know, what typically happens is you will cross-examine the applicant's witness. There was obviously issues raised there, but ultimately his information is in the record. Another witness has to come forward, a counter witness that would present that other side. It's not enough to show their issues again. So not everyone has the money to bring expert witnesses in. So so money available for one or two witnesses would be hugely beneficial. I still think that they don't need to bring an attorney in as long as they know how to work with it. And in the alternative, what the state of New Hampshire has done, I think it works well, is that they have a counsel for the public that is actually appointed by the Attorney General to participate. That individual actually serves as an intervener to represent the public in general. So that person does not represent the interveners that would choose to be part of the process, but invariably they work together. So that counsel for the public is is a person that could actually help the interveners understand the legal process. And so it would be, they actually could bring in witnesses as opposed to the interveners bringing in witnesses. That their funding would be it would be the component, and it would make the money available for that, I believe, for that individual. So that is another way of handling it. And then the last thing I wanted to raise is the difference between Section 248 and Act 250. And Annette may have more comment on this than I have, but the only thing I'd say about that, because there are obviously different approaches, Act 250 does have very clear rules and regulations around, for instance, blasting, that 248 does not. And so I would only suggest that to the extent that Act 250 has regulations, rules, requirements for development, can they be applied or at least accessed? And I'll give you an example really quickly. The CPG for Deerfield said, required that all blasting be performed in accordance with any and all applicable laws and regulations in the state of Vermont. And that, in my mind, that meant Act 250 has the regulations for all blasting. We should go look there. But in fact, that wasn't the case. And so anyway, just to the extent that 250, Act 250 and 248, you could find commonality there, that would be useful to look to 250. Thank you.
First of all, my first comment is I'll get the positive ones in there. The electronic filing, thank you. Stuffing 20 envelopes to respond to every single one of Andy's comments and having to make sure that they're all postmarked in time is a pain. It is an undue burden on a pro se party, period. So thank you very much for electronic, because that takes away half of my frustration in the last 10 years.
And Tom, I'm going to say you're sitting next to the person who really made it happen.
Well, thank you.
And don't forget Holly.
No, that's true.
Holly is your contact person when you run into a difficulty with EPUC. She helps you navigate it. And I have to tell you, I call her frequently.
So, and I say these comments, and I'm going to sound bitter, because I am, about the process that I went through. But it was not easy for me to get here today. I live in one of the towns that is furthest away from Montpelier by time in the state. I came here, I gained nothing from this other than to help people in the future. So all I'm trying to do is trying to make other people's experience less painful than mine. The other thing that's very good is the video conferencing and streaming it. Again, I came to most of the hearings for the Deerfield project. It's 2.5 hours each way for me. It's 2.5 hours. It's a whole day out of work. I had 2 jobs during that whole process. I had the job that I had and the job of coming here. 2.5 hours each way, doing all the research, responding to everything that happened. It's, forget being a college student, this is more work than I've ever done in my life. So the video conferencing certainly helps. I would hope that you make that available to any of the pro se interveners. You said you do it on occasion, but for me to not drive up here, 2 weeks in a row, 5 days out of 2 weeks, and then wait 2 weeks and do it again, would have really helped me. So that's the that's the positive. The negative, and this kind of piggybacks on what Lisa was saying, is that there's no citizens advocate. I got in contact with Lisa through another party that was doing another turbine installation in Massachusetts. So I got her name, and Lisa kind of walked me through what I need to do to not be a pain to the board on how I'm supposed to file and do the appropriate filings in the appropriate format. So if there was a person here that I could talk to and send a draft to and have them say, you did it all wrong, that would have been very helpful. And I would definitely advocate for that. I would personally pay more taxes if that was available to future people. Okay, just checking my notes here. The last is the really bitter part. I said I tried to intervene in '96. I called up Mr. Zimmerman, who's well known to the state, and was told that I couldn't intervene because I was not the landowner, which everyone here knows is a lie. So I got my mother to file as an intervener. My father had just died, and I had to get my mother to sign all the documents that I wrote up to be an intervener. Now, I didn't come to any of the hearings then, but to be treated like that when we were the closest people, 2 houses closest to the first Searsburg wind farm. And we were treated like dirt. We weren't notified. They said somebody named Wilson owned the property. Well, since the homestead, there's been 5 owners of the property. It's not hard. Everyone in my family has held public office in Searsburg. It's not a big town. How you couldn't find us, I don't know. I suspect that the developer had something to do with that, to make sure that they didn't notify us, because we're the only 2 houses that can look out our rooms, our bedrooms, and see the turbines. Everyone else in town is over the hill. You can't see the 96 wind farm. So you start with that, and I was definitely discouraged. The second time around, I said, I'm not going to be pushed around this time, so I filed. I filed as a pro se intervener. To me, that was, I can ask questions of the developer. I filed as a pro se intervener. To me, that was, I can ask questions of the developer. An attorney for the developer who used to work for the Department of Public Service, and you can figure out who he is. Please identify and produce all documents you and any other person working for you or under your direction prepared, reviewed, relied upon, or used in connection with the preparation of your pre-filed testimony. Not limited to raw data, other results of research, fieldwork conducted, any notes, drafts generated. Please identify and produce in original format all electronic files that were utilized to prepare my questions. No one told him that that's inappropriate. This is absolutely a bullying tactic on his part, and he used it not just on me, but on every single pro se intervener. Somebody needs to leash him in. And I'm not sure if other attorneys do the same thing for other cases. Please produce your curriculum vitae or resume indicating employment, education, and experience history. Identify and produce all publications you have authored within the preceding 5 years. My response was, the work I did for the Navy is classified, needing a secret clearance, and the work I was currently doing is proprietary and trade secrets. You can Google my patents online. Why do I need to produce that? Why was this not responded to by the board saying that's inappropriate? That's my bitterness. Now, that was just the first letter I got from him. It happened throughout the hearings. When I asked his visual expert on aesthetics, the wind farm will be accepted by Searsburg because there's already one there, so the residents will accept it. Excuse me, Ms. Vissery, did you speak to any resident of Searsburg? Amy, I object! Did you speak to any resident of Searsburg? No. Why was that accepted as expert testimony on aesthetics that it would be accepted by the town of Searsburg when she spoke to no one, and it was in a hearing? So that's how I feel the board treats pro se, and apologies because no one here was there then.
Can I just ask you what general time frame that was? I know the first experience you had was in 1996. When was this?
Andy's request from me to my curriculum vitae was September 2nd, 2008. And the hearings were sometime, I believe, December. So if this is supposed to be a citizen participation, when you come in and get bullied by attorneys, I'm not an attorney, but I'm an engineer. So I knew what he was doing. I've filed things before environmental permits for regulatory agencies, so I know what he was trying to do. But what if it was my neighbor that's a farmer and comes and says, I don't want the turbines 2 feet from my house? Is he going to bully them too? It's sad. So in my opinion, there was no public opinion that was sought in my case. That's the end of my rant. But thank you, and actually, thank you for holding these meetings too. That was the other thing, good news.
Well, thank you all for, again, doing the 5-hour round trip.
Yes.
That, I understand. how
At
hard
least
that
30
is.
times.
Yeah. And today.
Well, and today, thank you
Yes.
very much.
This is.
Well, I'm retired,
Yeah.
so,
It's still a long
so
time.
this is my job now.
But I'm sure this wasn't on your bucket list of things to do.
It was
in
not,
retirement.
but again, you know, I'll go back. I was serious when I said I don't want people to have to endure the pain that I did. You know, it should be, you know, Vermont, it was the citizens' country, right? They said they don't want 2 states taxing them, so Vermont became their own country, right? So it's governed by the citizens. And certainly in that case, it was not the case.
Okay. Mr. Grimm? Yeah.
Well, thank you, Lisa, and thank you, I don't have any vitriol, so we can relax. The project that I was involved with withdrew at a certain point, so we really never followed through in a complete process, but it did give me some insights into what was going on. When I got started and involved, there was another political administration of the opposite political party who was pushing pretty hard for these wind turbines. And I didn't have any opinion about the wind turbines because I didn't know much about them. They seemed pretty pastoral out on the landscape. But I was fortunate enough to get involved with a group of people who did have some knowledge to get started. And we all pressed into it as a group. We used the internet. There was 50 of us, 50 to 60 of us all together, and I know that because I helped form the internet group and kind of shepherded it during its activities. Going to Montpelier to see what was going on, I quickly learned that the public is a strange term. We all have our concept of what the public is. The Constitution talks about taking care of the public good. The government officials need to watch out for the public good. But the public good seems to be subverted behind politics and special interests. And it took me a long time to mature into understanding what that was all about. I think that it would be great if the Public Utility Commission kind of got a better feeling for what the public really means. I think it must mean all of those citizens who aren't part of a political party, not a strong adherent behind a particular political faction, or aren't part of a special interest group. And that has to be by far and away the largest fraction of Vermonters. So if the PUC can come up with a way to be sure that that large fraction gets the major amount of attention, way above what attention is being paid to the projects pushed by political parties and pushed by special interest groups, that would be a giant leap forward, really. And to my way of thinking right now, the only thing that really helps the public is this pro se process. And I'm 100% for it. I think what I've seen of it so far has been totally positive. EPUC has been incredibly fine. And I think what Sarah was talking about, streaming, I think that'd be great. And to the extent that you can really bring the public that I'm talking about, into the process, tremendous. Okay, I don't want to be too worried, but Lisa brought up noise, and that's been a bone of contention for me for some time. We talk about noise, we think about what comes in our ears, right? What if you're standing somewhere, say next to a man jackhammering the pavement? There's the noise you hear in your ears, but there's the noise you feel through your skeleton. And I think that that came into focus in some of the hearings that I attended. when an expert witness started talking about how people didn't sleep well, were irritable. They couldn't put their finger on it, couldn't understand why, but they sensed it had something to do with the wind turbines. So now, you all know that the seismographs in Cambridge, Massachusetts pick up all the little shakings and rattlings on our planet. If something happens out on the San Andreas Fault, they know about it in Cambridge, Massachusetts real suddenly. That's because the speed of sound, and here sound I'm talking about not just what you hear, but what moves through liquid and moves through solids, is transmitted very rapidly. Even on the quietest day, those seismometers are bouncing up and down. If you watch a graph, you'll see the thing going like this. You can't feel that, but it's going on all the time. If a fault like San Andreas goes off, then the lines on the graph go way up and down, and people next to it can really feel it. What do you think happens next to a wind turbine, which is spinning up and turning out a lot of energy? Where do you think that energy has to go? It has to be grounded, or the turbine will fly off. So it's grounded into the solid material down below. If you attach a small seismometer to the steel casing of a home drilled well, before you start the turbine, it'll be pretty quiet. You won't be getting much out of that. When that turbine starts, depending on how far you are away, that little home seismometer attached to the steel well casing, which is grounded into the ledge, will start to jump up and down. And that's the explanation for why people feel things other than through their ears. They feel it through their systems. Your human body is one of the most sensitive organs for detecting this thing, far more sensitive than any mechanical device. And I think that the Public Utility Commission do well to push into that area, because that really affects a lot of people in the public, you know. Okay, weight of testimony. Expert witnesses come in, they give their credentials, they tell you what they know. When a public citizen comes in, Tom pointed out, it isn't so easy. It's like, well, who do you think you are? You're coming here and telling us. If you've lived on the planet for quite a while and you have some experience, that has to be given weight. I don't claim to have expertise, particularly in wind turbines, but I operated a consulting engineering firm for 40 years here in Vermont and throughout northern New England, and I feel like I have a pretty good understanding of things that are going on. And I pay attention, and I am able to go on the internet and look into things. I would like to think that if I gave testimony before a Public Utility Commission, that I would get accorded weight to my thinking and feelings about things, even though I can't list specific credentials in a particular area. Some particular areas I could, but. Okay, this one goes to the actual hearing process. Over the years, I have had an opportunity to end up in a courtroom and watch the whole proceedings, judicial proceedings. And one thing came to my attention fairly early, that some judges make you feel at home. I feel comfortable in this room right now. I feel relaxed. You're the chairman, but you've been very easygoing on us, hasn't given us a hard time. And that's a nice way to conduct, even though this is supposed to be informal. But even in a formal proceeding, I'm going to give you a name, and you probably have run across him in your time, and that would be George Costas of St. Albans. He was a lawyer for many years and served as a judge also. A personal friend for many years, so I may be a little biased. Anytime I was in his courtroom, I always felt relaxed and at ease. He just put you at ease and didn't make you feel like you had to be sitting on edge. And to the extent that the commission can foster that kind of feeling during any hearing, whether it's formal or informal, I think that's a very important thing to do. And I think from what I can see, you're off to a good start. I think that's about it. Thank you.
Okay. Who of you two who are on the phone would like to speak next?
Christine and Justin.
Okay, this is Christine. I've heard a lot of good things today. I think Lisa brought up a lot of the same points, and Tom and Greg also that we were thinking of. Our first experience in front of in that hearing room with the hearing officer honestly was the worst experience of my life. We were treated horribly in that, and then when you said that the hearing officers were going to get training, I mean, that to me was huge. And we have seen improvement since then. That was 3 years ago, and we have seen improvement since then. But I mean, if it wasn't for Annette, we would have had no idea what to do, where to go from there, how to do anything. Everything that's done has to be done in a legal format. And there is no legal help for a pro se intervener. Even from the start, even trying to intervene, we were just in a Met Tower case, which really, honestly, we shouldn't have even had to have been involved. That was somebody put up a Met Tower without a permit. That should have been it. We reported it, and it should have been taken care of. 3 years, and it's still going on. And we were told, we were abused by the lawyers too, so I know exactly what Tom is talking about. We were subpoenaed, we were, there was Supreme Court, she went to the Supreme Court on us, and many times, at least 3 times in talking with different people at DPS, we were told, you should get a lawyer. You should get a lawyer. So there's no, why should we get a lawyer when they put up a Met Tower without a permit? What do we have to gain? We have nothing to gain, and we simply wanted to bring, the facts that we knew into the case, and that was it. And the same is true with the Swan Wind project. You just want to be able to participate, but it's pushing against you at every step. And everything had to be done in a legal format. And the lawyers for the developers, the developers are putting money into this because they want to get money back. As a pro se intervener, you're not going to ever get any money back. All you're doing is trying to preserve your what you own, which a lot of times you've put your whole life into. So, you're never going to get your money back. So putting in thousands and thousands of dollars and having to hire experts because, the information, you can't bring anything forward unless it's brought forward from an expert. And experts are very expensive, and there's so many different areas in a wind project. So, I really think there should be some money from the developer when they file an application that's to provide for experts, for the pro se interveners. And I also believe there needs to be a lawyer, and I think it was Tom that said, someone who, a pro se intervener can give, I'm going to file this I'm thinking of, this is what I've come up with for this document, either to intervene or somewhere else along in the process, and they could give them feedback and help them with it and stand beside them at the hearing and tell them what's the right thing to do. As a pro se, you don't know when's the right time to talk, when you can talk, when you can't talk. And also at that very first hearing, the DPS and the lawyers, they all got together beforehand, and we're all talking beforehand, and they sat down and said, oh yeah, we've kind of worked out a schedule. And that's where we're like, well, hey, what about us? And they're like, well, you don't matter. And so those things, they need to be brought together. So those are the main points that I have, and I think Dustin has a few things also.
I'd like to support some issues that Lisa brought up and also Tom. First of all, the technical evaluation of impacts. I'd like to cite the example of the Kingdom Community Wind in Lowell. The proposed turbines were Vesta V90 at 2 megawatts, 410 feet. After the CPG was issued, the developer changed the turbines to Vesta V112, which were a 3 megawatt turbine at 459 feet, almost 50 feet taller. All these impacts in the technical evaluation were based on the smaller wind turbine. And then we're dealing with a larger wind turbine with different impacts, which were not even considered. So that's point one that Lisa brought up, and I'd like to support. Something has to be done there. If Walmart were to propose a 90,000 square foot store footprint, and then when it came time to build the building, they built a 110,000 square foot store, there's quite a difference there. And I don't see why wind turbines should be treated any different. Also, the testimony, again, needs to be from expert witnesses, which costs money. And our voices don't matter in that area, and that's an expense that we incur and are unable to, unless we want to empty our pockets and deliver our life savings to an expert witness and attorneys. Also, Tom brought up the fact of an adjoining landowner, which we were at the time, and the past practices of the wind industry and their attorneys has left some bad blood in the state, and I applaud the Public Utility Commission for seeing the faults in the system and and acting to improve upon them and make a level playing field. And that's about all I've got. Thank you for your time.
Thank you for having us here. This is huge, and getting an echo on it.
Thank you.
So we really appreciate it, and we know that, you may not be able to do everything, and you may have to go back to the legislature for some of these changes, but we respect the fact that you are listening to people. You do realize that there have been issues, and we really appreciate this. We hope no one ever has to go through what we've been through, and just like Tom, we're not in it anymore, but we're here because we don't want anybody else to have to go through it.
And I think that's coming through loud and clear. And I think Tom, you apologize for being, I don't think you have to apologize. It's, you can be angry, and it's really okay. We're here to hear that today to see if it's not like we can fix everything, okay? But what can we fix? What can we not fix?
One thing I wish we could fix.
Yeah.
Don't ever ask any pro se intervener what their resume is. Tough. I'm a citizen. Period, he said. And seriously, he should be reprimanded. And for asking me what I did at the Navy, I should have reported him to Naval Investigative Services because he wanted classified information. He wasn't allowed to get it.
I do want to point out, it may be obvious that we are not the department, but we hear you loud and clear. But
well, that
was from the developer's lawyer.
This was from Andy.
You're talking Andy Robogle?
Oh, yeah.
Okay.
no, but I mean, is the Department of Public Service, I thought you were talking about their...
He said he used to work for the Department of Public Service.
In '96, he was the Department of Public Services attorney for the Searsburg Wind Project.
Right.
So he moved to the other side of the table and has made much more money on the other side of the table.
Okay, now I understand.
Okay, Annette, you've sat in the wings. Are you ready to come on stage?
I'm ready. You ready for me? Okay.
Well, I don't know.
I have pulled up page 3 of the Citizens Guide. It has a very nice flow chart of the procedural steps, so I'm going to go through them and point out the areas that I have found problematic. So I'm starting with advance notice. And the advance notice is very good when it comes 45 days before the petition is filed. But we've seen several cases, and the Langs were involved in one, where the advance notice was filed something like a year or more before the application was filed. You have fixed this to some extent in the net metering rule, where you say that after 6 months they have to refile an advance notice. I think you need to do something similar. I think 6 months is still too long, but I don't know. I'd kind of like to step back for a second and ask Christine or Dustin to speak to what that was like for them.
Well, you get all hyped up and you have to, you know, and the town gets involved and all this stuff, and then all of a sudden it's like nothing's happening. And then when they did file, it was like no warning to any, it felt like no warning to any of us because it had been so long. And we had no idea, you know, when they were getting close to the filing. So yes, that was tough.
Okay, thank you. Next, petition file. I'm observing some issues with the good practice you're doing now with finding that a petition is complete. However, the notification process doesn't extend out, and so I've actually missed 2 determinations of completeness, and it really matters because you have 30 days, according to the rule, to object to any pre-filed testimony, and so that's something that you need to look at internally to make sure that, and I'm not clear at this point whether a complete application is when you have declared it complete or when that notification has gone out. And this has actually been an issue in a recent case involving a regional planning commission. So there are, with the certified plans and those dates and when they come into play, you need to clarify what is the date when a petition is complete, and also how that affects the people who need to be notified. I should step back and say that the way that I got involved and Vermonters for a Clean Environment got involved in PUC cases was, as Commissioner Hoffman knows, I was involved many years ago in 1999 and got up to speed on the PUC, and then stepped away and did a lot of Act 250 and A&R and ag work, and then in 2009 re-engaged. So I was watching the PUC for several years and assisting people in the background, but then when a lot of these solar projects came along, we started getting just inundated with phone calls. And so we would help the citizens, and my staff person would bring the filings in, and the way that we learned all of the rules in terms of formatting and everything was that the previous clerk would reprimand us for doing it wrong. And she was very nice about it, but that's how we learned. We didn't learn by necessarily reading the rules. We just did it wrong and then got told how to do it right. I view a lot of my work as just secretarial, and I still notice that there are attorneys that practice for developers who aren't following the rules in terms of formatting, and that's just sort of a pet peeve. Pre-hearing conference. Christine touched on that a little bit. The way that the process is run, the Department of Public Service and A&R, the statutory parties, have these discussions, and they come in with a schedule. The citizens come in. If they haven't hired a lawyer already, they're already way behind. They have to come in, and they're told, well, you don't have party status, and you get to go through the process of filing your motion to intervene, but that comes later, and the schedule's already been established. And so the citizens are really cut out of the scheduling discussion, and the way that the process then goes is downhill from there, because usually in the past there has been a first round of discovery already by the time the motions to intervene are ruled on. I was working with people on one case where the evidentiary hearing was actually scheduled before the hearing officer had ruled on a motion to intervene. That sort of process, procedural thing, is very, very challenging for pro se parties to deal with. There have been cases where the department has correctly argued that discovery should not start until all motions to intervene have been filed, and that was done in at least one case, but I have seen it backsliding since then. So in fairness to the pro se parties, they need to be involved from the beginning, and discovery shouldn't start. I've heard this many, many times from citizens, and it was touched on a little bit, But the role of the Department of Public Service and the Agency of Natural Resources is incredibly problematic for pro se parties because all of this work goes on ahead of time with developers. And in particular, especially at the Agency of Natural Resources, if you want to get the speed on a project after the fact, in some cases we've experienced that the Agency of Natural Resources will not produce documents that are relevant to the case because they say it's part of litigation. And maybe the PUC could issue a memo or an order noting that this is not that this is an administrative proceeding and it shouldn't be subject to denial of public records due to litigation. I mean, the public has a right to know, and I think certainly in the case the Langs were involved in, they became aware that there had been discussions with the Agency of Natural Resources going on for quite a while. So site visit. The only issue I've noticed with site visits is that we, as the only organization actually following the PUC and trying to develop a case study so that we can help inform what you're doing right now, is that it's very hard often to find out when site visits are because they are not listed in the same order for the public hearing. And so we often have to call the clerk to find out when a site visit is being scheduled. And it should be on the calendar, and I don't know why you don't put site visits on the calendar. You have heard, I'm sure, before, and a lot of the people on the gas pipeline sites have said it, that public hearings are essentially meaningless. That, while I understand the purpose of it, the public does not. And it's problematic in that the voice of the public is not taken into consideration in your decisions, and it is at that public hearing where the public first becomes aware that they don't really matter, and that is a real deterrent to any participation. The intervention deadline is the next thing on the list, and again, I've mentioned that it is problematic, and I'll stop there to talk about EPUC and the changes that I've seen, which are, for the most part, incredibly good, and I applaud Ann and Holly for all of the good support they're providing. They literally have addressed just about every issue that I've raised. But there are some that I've raised that haven't been addressed yet. I have yet to work with a citizen who actually can do EPUC on their own, and I've pointed out in recent emails to Ann some of the problem points. It's still challenging. And the other issue is that when you do come to an evidentiary hearing, you often want to have a printed case, and so you still have to print out everything. In a recent case, the bill to print the case was over $300. So while it's a huge improvement over printing and mailing, it still does not come with zero cost if you are a person who can't do things entirely online or on a computer. Discovery. This is the big problem for pro se parties, or one of the biggest problems. What Tom experienced, and he said that he didn't know if other attorneys did it, yes, and Christine said yes, another attorney did it, and I've seen other attorneys do it. They use the discovery process as an abuse to bully, and I have seen, and the problem with it is that you all don't see any of it. You'll see the questions that are submitted, but that's all you see. And when it gets to the petitioners filing discovery on pro se parties, they tell them things that, honestly, if these citizens didn't have me to come to, or somebody to find out, do I have to do this, they would do it because they're under threat of sanctions, monetary sanctions, motions to compel, and I've seen things demanded of citizens. One attorney said he was going to send a forensic computer expert to the home to scour their emails for every email relevant to the case. And the citizens don't know that they don't have to succumb to that sort of thing. So there are no protections. It's often done one-on-one with just the attorneys. No other parties are copied. And that's also true of scheduling, too. When it comes down to trying to determine a schedule, no matter what stage in the case, the state agencies aren't copying the pro se parties on the responses, and so my practice would be to say, wait until you see what the state agencies say first, and then weigh in. But then it turns out the state agencies never said anything, and you're dealing with hostile, aggressive well-paid attorneys who are happy to badger the citizens in ways that I find so appalling, and that there's nobody to protect them. It makes me very sad to watch what's going on in so many cases, and it's not unique to one attorney, but there has to be some protection for these people, and I have suggested that you consider a whole separate category for pro se parties that's more along the lines of what I understand from attorneys is done in regular court, where there is no pre-trial testimony, there isn't discovery. They come in and they do their testimony live on the stand. It's lay witness testimony, and if they want to be experts, then they put in a report, and then they're subject to pre-trial testimony and discovery based on those issues. But to go after people's private lives the way these attorneys are doing is really a problem, and my role in it has become a liability because all these attorneys are very aggressively going after my correspondence, and it doesn't have the protection that lawyers have. And so while I don't think that many people have actually turned anything over, and while I am aware of at least one motion to compel that thankfully the hearing officer didn't require, it's a threat, and it makes it hard for me to do anything now because I know that if I engage in assisting people via email, then the parties themselves get threatened. And I end up feeling really bad that I put anything in writing, and I can't do everything by phone, which is why I've said to you, I can't do this anymore. It is just, I'm not a helpful person when I am part of the problem that because of the abuse of discovery. Testimony and exhibits. That's, what happens with lay witness testimony? It gets treated as expert witness testimony and subject to all the things that experts are subject to. It's hugely problematic. Stipulation or MOU, that is a big problem with many of the people who have not come to talk today, but you hear it over and over and over again. The MOU practice with DPS and A&R, the public is cut out of it. Some people have alluded to that already. All these negotiations go on. The parties are not included. Under the previous administration, DPS agreed to stop doing MOUs unless they included the other parties, but I don't know that that's happened. But A&R is still doing MOUs. Essentially, what's happening now is that the Agency of Natural Resources is cutting deals behind closed doors, and no other parties are subject to it. But then none of the issues can get really litigated before you because you're accepting these MOUs, and you accept them as though A&R is the final word. And so I see this resulting in very poor environmental protection. And I also I'm getting now to evidentiary hearings. Well, how many hearings have you all seen where and maybe it's more the hearing officers, where the state agency attorneys, and we're talking about agriculture, historic preservation, A&R, and Department of Public Service, sit through an entire hearing and don't ask a single question? We've documented many, many, many of those types of hearings. Meanwhile, who is it who's ending up having to do all of the cross-examination and carry the ball in contested cases? It's the persons. There's something really wrong with our situation here where the department, in the role of public advocate, is not even asking any questions. And in my view, a contested case means a contested case. And for you decision makers, the best decisions you make come from a fully contested case. So just like when you have debate teams in high school or college where each side is assigned a side, when there is a petitioner making a case, then the other side should also be making the opposite case just so that you all can grapple with the best evidence possible. You're not getting the best evidence. You're getting one side of most stories. It is also a problem with Act 250, which has often been called one-hand clapping, but it's imperative that something happen, whether it's intervener funding, a counsel for the public, some other thing that may require legislative change. There has to be a real contested case if there's going to be a contested case process, unless everybody comes to Jesus and agrees. But when you have contested cases, they really should be fully litigated, and they aren't. Briefs, I have yet to find a citizen who understands at all what a brief is, how to put a brief together. I've looked at all kinds of different briefs from attorneys. There is no standard format. Some put findings of fact in, some do it more as a narrative. I I don't know what it is you want in terms of a brief, but it's then when it gets down to the decision, it is as though the public wasn't even there. And that's the biggest problem that PUC faces with its credibility and with its public participation, is there is no incentive to participate because the track record is that you approve everything. And I can point to a couple of cases in the last year or two that have been denied, but when you think of the thousands of CPGs that have been issued, the record is very clear. It's clear to the public, and those who do participate come away saying it's as though we weren't even there. I think that in terms of this investigation you're doing, it would be very useful for you to compile a list of all the cases where the public has participated, where it has gone to a contested case, and I think you will find there are so few of them. That, to me, is the biggest red flag for the failure of the public process at the PUC. I hope you will be making a list of the things to take to the legislature that you can't do. We would be very glad to work with you and the department, because I know there are a lot of things that need to be changed going forward, and there are a lot of things that you probably can't do yourselves. So I think that is kind of sufficient for now.
Annette, do you have a list that you'd share with us? I mean, you're saying we should make a list of things to take to the legislature. I was just wondering if you have a list that you would be willing to share.
I've had lists over the years. I will be working on it. I will be working on a new one. I mean, one of the ones that's been mentioned is that the way that developers get to choose the model wind turbine after the fact. That's clearly something that needs legislative attention. Intervenor funding, I assume, would need legislative attention. I'm very interested in what Lisa talked about the Council for the Public, but there's some other things that have gotten through the legislature that need to be undone, but there are also some new things. So yes, I'd be happy to share that with you.
Thanks very much.
Mr. Chairman?
Yes.
If I could just comment on one thing. To be fair, the adversarial process is very difficult, and I've worked with a lot of citizens that have participated in the process, and I think it's hard on the PUC to say that you need to be fair to the public and listen to the public, because when it really comes down to it, many times their testimony is, it takes a lot of time and a lot of understanding of how to present data in a way that can be used by the commission in making a decision. So sometimes it can be very emotional, and just trying to dissect what the person is trying to say and use that as part of informing your decision. It's not easy to do, so people do have a tendency to walk away feeling like they weren't listened to, and I don't know how to fix that problem, but I just want to be fair to the PUC. I think the public needs to understand there's a process too, and there's data that needs to be presented, and it can't be all emotional. But the point I wanted to make to that was, to the extent, getting back to my point about the application, to the extent that you can work on rules for very specific technical issues, especially around wind, and I know it will apply to other applications, I think a lot of the concern would be dealt with. I mean, I think there's just so much anxiety about how noisy is this turbine going to be, and how well can we trust the people that are going to be doing the studies. There's so much anxiety around that can be eliminated, and the aesthetics, and also the order. So what Annette was saying in terms of the turbines changing after the fact, and just all of a sudden we're not working. The ground we're standing on is just not solid. That's what makes everyone feel very upset and distrusting of the process. And just one last point, if you are able to go down that route of getting a very detailed application established and rules for what are in the application, then the completeness decision, right now, if I understand your rules, and similar to New Hampshire, the completeness decision is made by the commission, and since there are no interveners at that point, there's no opportunity to object. I don't know who would object if you made a determination about completeness when other people said, wait a minute, they're missing all of this other stuff and they're not abiding by the rules. So if you do go down that route, I would hope there'd be an opportunity somehow to object to a completeness decision, rather than having to go all the way to the adjudicative process and say, they didn't do the study right. That whole application process can save a lot of time and eliminate a lot of anxiety, in my opinion.
Let me ask you all a question. There are a couple of different ways in which a pro se can participate as a witness. Tom, what you were describing, it sounded like you wanted to present some facts, and you were subjected to what you thought was inappropriate discovery that, at least arguably, wouldn't relate to whether or not, I mean, if you said, I saw 2 deer in the yard, you don't need to disclose your resume before you can say, I saw 2 deer in the yard.
I would say that my primary purpose was to ask questions because I didn't believe what they submitted. It wasn't to provide my opinion on anything other than Searsburg. When I was a kid, I could know where I was by hearing the streams, and I can't do that anymore. That's the only opinion that I had, right? I wanted to ask questions, and I don't know why I need a resume to ask questions. He wanted to know conversations that I had with my wife. That's a despicable human being, in my opinion, to ask that question, right? It's a private conversation. For me to ask a question, and the only thing that I had done to that point was to ask questions. I had submitted my questions to the developers, well actually to the board, but to ask the developers to respond for the sections that I was allowed to be an intervener. I submitted no exhibits or anything.
Okay, so one way a pro se can participate is to ask questions. Another way they can participate is to give facts. And a third way they can participate is to give opinions. If pro ses, and as I understand it, the pro ses offer opinions because they don't have funds to hire an expert to offer the opinion. So you'll have a pro se that reads literature and then says, well, the studies show, which is arguably an opinion. How much of a difficulty is it if the interveners are not offering opinions? In other words, if all they're doing is offering facts. For example, here's a study. I'm not going to offer my view of what I think the study says, but here's a study that I want to put into evidence. Or here's a fact that I know from my own personal observation, like that there were 2 deer in the yard. Would it be a significant impediment to the intervener if the intervener were not presenting, I'm not suggesting prohibiting it, but if the intervener were not presenting opinions, but were only presenting facts or documents? What do you all think?
I think if you have a person who has a lot of experience, life experience, that opinion has to be given some weight. Because to some extent, the so-called expert witness is offering an opinion. He's grounding it in some science. But in the end, it's an opinion. So why not let the citizen give his opinion based on his life experience? Give it some weight.
Difficulty, though, I think, is that a lot of people don't know whether they're presenting data. They can't tell the difference between an opinion and data. And so it will fall to you or to other people to kind of decide that. But opinions, so for instance, if the wind guy, noise expert says this is the maximum noise that the turbine's going to put out, and someone gets up there and says, I don't believe you, like Thompson, I don't believe that. I know I've heard the turbine's louder than that. Well, what data do you have? I mean, how much weight can you put on that? It's really hard for you to put any weight on that. So I guess I'm trying to understand your question, so is it too much of a burden for them to make it you asking for them to make a distinction? Or?
No, really the underlying question is the role of discovery is to test the opinion where it's an opinion, or the fact where it's a fact. And in theory, discovery should be limited to the bounds of what the person is asking. So if Tom says, I want to tell you how many deer there are in the yard, it would be difficult to justify having discovery of Tom about, well, what's your resume?
All right.
You might ask him, do you wear glasses? But you wouldn't ask him, where'd you go to college? Or, what did you and your wife talk about? On the other hand, the more you get over into opinion, then the more part of discovery is to test the credibility of the witness. So the more the pro se person wants to offer an opinion, the more they at least arguably open up this question. Now, this is not unique in the PUC. In the court system, the same thing happens. I mean, I've had cases where I have a witness who wants to get up and testify about what happened to them. And the other side wants to find out what their drug use history was. And technically, it had nothing to do with what they were asking, but the person asking the question always said, well, they're reporting something they saw. If they're a drug user, it undercuts the credibility of what they've just said. And this is used as like a universal solvent. It allows anything to happen. So, your questions all raise for us questions about should there be limits on discovery? And it can't be that the limits are uniquely to one party, but not the other party. So, and I'm just trying to understand where the intervener, pro se intervener, feels they are most comfortable and what steps they would take in order to restrict discovery and how much that might restrict them offering what they want to offer in the case. That was all I was asking about.
In the end, if you're a little loose and easygoing on that, isn't it the role of the commission to sift the fly manure from the pepper, and so to speak?
Yeah.
That's what you're doing.
Right, yes, but obviously our goal is to limit the amount of manure we have to sift.
I do have another question. I'm sorry, go ahead, Annette.
It's an interesting question, Mr. Chair. The problem is that the discovery process isn't policed in any way. You guys don't see it. You don't see what goes on. So if there was, for instance, a counsel for the public that was copied on all the discovery questions, then there would be someone to be in the role of protecting the citizens. But with the way that the process goes now, it's just between the petitioner's lawyer and the citizen, and they're going way, way, way off of topic. And, I think there was one case that a couple got something like 290 discovery questions, and then kept coming back to compel more and more. And those are the kinds of cases that, as Greg suggests, that it isn't the role of the commission. You don't play a role in that sort of thing, and that's really problematic. I also wanted to respond to one thing Lisa said. That idea of that we weren't even there, that extends to cases where the citizens spent hundreds of thousands of dollars on lawyers and experts, and at the end of the day, that's what they said. And there's one other thing that I didn't mention, and that is what a problem the rules are. Because there's the rules of civil procedure, the PUC's rules, citizens have to learn all those things, and what happens in the evidentiary hearings is, and I've seen it over and over and over again, if a pro se party sits in the room and tries to do something, the petitioner's attorney will cite a rule, and that immediately is just overwhelming to the citizen. They don't know how to respond. They don't know what Rule 56 is or 49 or whatever those things are, and that's used liberally as a way to intimidate the pro se parties. Okay, I'll go back on you.
I had a question, something I struggle with. Almost everyone mentioned it, which is this idea of you come in, the schedule's already set, and intervention hasn't even been set yet. So my quandary is, where do we put, should we have intervention earlier? I have a memory trace, and Annette, you can tell me if I'm wrong or not, but I have a memory trace of citizens saying they wanted intervention after the public hearing. And so I was at the department at the time, so we pushed the intervention until after the public hearing. But I'm also hearing that that feels like it's too late. Do you want interventions earlier? We do that in rate cases. We don't necessarily do it in citing cases. But what would be a good place to put the intervention in?
I think it's appropriate to put it where you have it, but a number of lawyers have said, I don't know why they call it a pre-hearing conference. It's really a scheduling conference. So more of the question is, where is the appropriate place to put the scheduling conference? Should it be after the site visit public hearing motions to intervene? I hear your quandary there, but maybe the schedule needs to be developed after the parties are identified and separate from a pre-hearing conference where issues can be raised that get everybody on board and you agree on when the public hearing, site visit, and pre-hearing conference is held, and then you have some sort of a phone status conference after the motions to intervene to develop the schedule. That's one suggestion for how to handle it.
I think the point is really well. I take the point, it is an issue, and that is, and the state of New Hampshire struggled with this as well, and that is even if you decide you want to intervene and actually bring an expert witness in, you have an applicant who's already spent a year and a half, maybe longer, doing all his studies, and you're just like kind of squeezed into this period where between intervention, acceptance, and the hearings where you have to come up with your arguments why there are issues with the application or the project itself. And there's no time really to do that. So I keep pushing this whole thing about on the front end, if there's prior notification, even before the application is submitted, I don't know if New Hampshire, Vermont does this, that something is in the works and that people can start kind of working towards understanding whether they want to participate, even some preliminary application process. That, and that was saying that work is being done with A&R and maybe DPS. Department of Public Service, but if the public could be made aware of it. There's no reason why that should be kept confidential. I don't think this is confidential information. And so.
Well, the public, in my case, the public was informed because they went into Reedsboro, whose nearest house is 5 miles from the turbines right now. They went into Reedsboro, who was going to get money from the developers, so they were all for it. They didn't have one in Searsburg until after the application was put in.
Yeah, see, I don't think that's unusual. I think in the case of wind projects that I've dealt with, the people didn't find out about it unless they were an immediate butter to the project site and there was a wetland that was going to be impacted. And then they were notified because there was a wetlands permit that was submitted to the state. So it had nothing to do with the application per se. So notification by the applicant, put some responsibility on the applicant to notify people would help.
I have a comment that I omitted, which actually I thought of in our discussions here, and it involves the other end of the process. So right now, the turbines are in there, but they have to comply with a certificate of public good. I have a foot of water in my basement. It's a 100-year-old log cabin. I didn't have a foot of water until they started blasting. I have 2 means of recourse. The one I'm pursuing is I'm going to, out of my own pocket, create some drainage so that I can deal with water flowing through my basement now. The other means of recourse is to go to the developer, and in 100% of the cases, they require a gag agreement for any settlement. Things to do to the legislature prohibit that from happening. I'll tell you, I would never sign a gag agreement with this developer, ever. I would have my last penny and would never sign a gag agreement with them. That is evil. More than one of my neighbors have had damage to their house from the blasting. They got it fixed, but Donnelly can never say anything bad about the turbines. And that's a problem. I don't know how to fix it, right? And it's, I know that the board doesn't want to be, the civil court, right? Small claims court, to hear every complaint about something that's operational, right? And the first response is, if you file a complaint, is go try to do mediation with them. The flaw in that is that they, 100% of the time, require a gag agreement if they make a settlement.
The Stormy Daniels issue.
Well, I didn't think we'd hear that today.
We've gone beyond ours, I think.
Well, thank you all very much. This has been, I've taken copious notes. Some of you are echoing things that I personally believe. But as you know, my job is not to pursue my personal agenda here. But those concerns are all very important for us to hear. And while I can't tell you that, okay, everything will be fixed, I can tell you that thanks to efforts like what Margaret did with the Act 174 working group, we are moving in the direction of making the process as effective and fair for the citizen that comes with limited or no resources, but genuine concerns, and we're going to keep doing that.
Excellent. Thank you. Yes, and thank you all for taking all the time to be here and be thoughtful, including to you, Greg, for the
Give us advance.
Yes, what you
Thank you.
submitted in writing, that was food for thought as well, so thank you.
Thank you.
Thank you for doing this. 10 years ago, I would have bet a substantial amount of money that this would never happen. So it's very good. I wish you'd done it, well, not you, because you weren't in this position. I wish it was done 20 years ago, and I'd have more heartbeats left in my life.
Mr. Chair, I have notes, I just intended to deliver on them and became very messy, but would you like
Sure,
this to be?
of course, of course.
To Victoria?
You can give them, well, our clerk is here.
They're not in a form that I could hand them to you, but I would be happy to email them, if that's okay.
Yes, that's perfect.
Okay.
Sure, and you can send them to Victoria or to the clerk's office.
Okay.
Great, thank you.
Thank you. Thanks, everyone.
Thank you, everyone.
Annette, thank you, as always.
And thank you.
You're welcome, and I do appreciate you doing this.
Thank you to the Langs, too.
Yeah, thank you.
Yes, thank you.
Blackman?
Bye.
Good luck with the cabin.